By now, you've probably heard about the dismissal of the cases against James Comey and Letitia James. You may have also heard that the dismissal of those cases was without prejudice, meaning the government can get to try again as a technical matter. But today on All Rise News, I'm going to point out two footnotes in those rulings that will make it very difficult, if not impossible, for the government to be able to do that in practice. I'm going to break it down for you today on All Rise News here on Legal AF, part of the Midas Touch Network. Take a moment to hit subscribe. And before we get deep into that ruling, I want to play James Comey's statements in full. He released a video after his victory, and he and his lawyers are interpreting this as a final win.
I'm grateful that the court ended the case against me, which was a prosecution based on malevolence and incompetence, and a reflection of what the Department of Justice has become under Donald Trump, which is heartbreaking. But I was also inspired by the example of the career people who refused to be part of this travesty. It cost some of them their jobs, which is painful, but it preserved their integrity, which is beyond price. And I know they will serve again. I was very lucky that some of the best lawyers in America stepped forward to represent me. I hope they serve as an example to more and more lawyers, especially at some of the big firms, to participate in protecting our liberty, protecting the rule of law. And my family and friends were always with me, and luckily for me, include some of those great lawyers. This case mattered to me personally, obviously, but it matters most because a message has to be sent that the President of the United States cannot use the Department of Justice to target his political enemies. I don't care what your politics are, you have to see that as fundamentally un-American and a threat to the rule of law that keeps all of us free. I know that Donald Trump will probably come after me again, and my attitude is going to be the same. I'm innocent, I am not afraid, and I believe in an independent federal judiciary, the gift from our founders that protects us from a would-be tyrant. When I was a kid, my parents would wake us up for school every morning by snapping open the shades and saying, "Time to rise and shine and show the world what you're made of." Well, it's that time, America. It's time to stand up and show the fools who would frighten us, who would divide us, that we're made of stronger stuff, that we believe in the rule of law, that we believe in the importance of doing things by the law. So stand tall, shine, and keep the faith.
Now, of course, most legal observers believe that appeals are inevitable here. This will go to appellate courts, and the Trump Justice Department will probably try to file these cases again. But here are two major obstacles in their way. I'm going to start with the Comey case. James Comey was indicted right before the statute of limitations on his case expired. It's a 5-year statute of limitations, and it is a case that goes to his September 2020 testimony before Congress. It was indicted just days before the statute of limitations expired on this case. And federal prosecutors have argued that that doesn't matter because, one, once an indictment is returned, the statute of limitations is told, that is to say, paused. There is a second argument that prosecutors say there should be a grace period when a indictment is tossed on procedural grounds that goes to a different statute. Here's a footnote that could be crucial to Comey's defense pushing away both of these arguments. It's footnote 21, and it reads, quote, "Generally, the return of an indictment tolls the statute of limitations on the charges contained in the indictment. An invalid indictment, however, cannot serve to block the statute of limitations as it swings closed. A valid indictment insulates from the statute of limitations problems any refiling of the same charges during the pendency of that valid indictment, that is, the superseding of a valid indictment. But if the earlier indictment is void, there is no legitimate peg on which to hang such a judicial limitations tolling result. And so the statute of limitations, according to Judge Curry and according to this ruling, is now expired, at least as regards to James Comey. The ruling still allows dismissal without prejudice, but it remains to be seen as a practical matter, and this will be litigated, whether the statute of limitations is now closed and prosecutors cannot try again. That's Comey's position right now. Now, the same issue doesn't exist for Letitia James, at least so far as the statute of limitations is concerned. But there is an issue in both the cases of Comey and James that could make, as a practical matter, it very, very difficult for prosecutors to try to bring these cases again. And it goes to an opinion from the 1980s brought by Samuel Alito before he became a Supreme Court justice, and he was working in the Justice Department's Office of Legal Counsel. And just shortly after the passage of the law that governed the appointment of interim U.S. attorneys, the central legal issue that led to the disqualification of Trump's former lawyer turned rookie prosecutor Lindsay Halligan in this case, Samuel Alito wrote an opinion that the judge cited in her ruling to disqualify Lindsay Halligan. This is from the judge's footnote. Quote, 3 days after Congress enacted the 1986 law, an Office of Legal Counsel memorandum authored by then Deputy Assistant Attorney General Samuel Alito concluded that the statute does not allow the Attorney General to make another appointment pursuant to subsection A after the expiration of a 120-day period. That statutory plan, Alito reasoned, discloses a congressional purpose that after the expiration of a 120-day period, further interim appointments are to be made by the court rather than by the Attorney General. I'm going to repeat that last line. By the court rather than the Attorney General. That means the judges of the Eastern District of Virginia would have the authority to, and the sole authority, to select Lindsay Halligan's replacement. Now that is critical because this case began after Donald Trump pressured out Lindsay Halligan's predecessor, Eric Siebert, and Lindsay Halligan in that position, having had no prosecutorial experience, overruled the objections of every career prosecutor in the Eastern District of Virginia, which raises a question. In the wake of this ruling, with a federal judge finding Lindsay Halligan's appointment unlawful, can the Trump administration find another U.S. attorney or other prosecutor who is both qualified for that position and willing to bring the cases that no other prosecutor in the Eastern District of Virginia wanted to bring? That in all of their judgment, these were cases that were not worth indicting, were not worth bringing to a grand jury, and in fact, raise ethical concerns. We've learned over the course of this litigation the measures that Lindsay Halligan took to convince a razor-thin majority of the grand jury to indict here. We found out that the grand jury was told by Lindsay Halligan that they could shift the burden of proof from the government to James Comey, that they could assume that the government had perhaps more evidence, even better evidence, than the government could even present, and that the evidence that the government presented to them might have been obtained in violation of the Fourth Amendment protections against unreasonable searches and seizures, and may have included attorney-client privilege materials. Are they going to be able to find another prosecutor willing to present that case in front of a grand jury, to take the risk of bringing a case that the career prosecutors of the Eastern District of Virginia had said was an ethical, essentially, they concluded that it had all of these ethical problems. It could be an ethical landmine. So there's a very real question here, whether Trump's Justice Department can find someone willing to carry out this case and file it again in the wake of this decision. And of course, the citation that Judge Curry had read out in that ruling that I cited right now, that was from Justice Samuel Alito before he became a Supreme Court justice, which carries the weight of that authority as this goes up all the way to the Supreme Court. So there's a lot that remains to be seen. This is going to be litigated. Everyone expects the government will appeal, and I'll be following it down the line here for All Rise News. If you want to catch up on this and other stories, you should visit www.allrisenews.com. That's www.allrisenews.com. And if you become a subscriber, you support my work and you stay up to date about the cases that matter. And to see other videos like this, hit subscribe now on Legal AF.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.